JBS presents a television exclusive, The Dershow with Alan Dershowitz.
The Senate is planning to put Mr. Donald Trump, ex-President Donald Trump, on trial after he leaves office. Can they do that under the Constitution? Stay tuned for the Dershow's constitutional seminar on that pressing question. On January 20th at noon, President Trump becomes ex-president and a private citizen. Yet the Senate of the United States may place a private citizen, Mr. Donald Trump, on trial under provisions of impeachment, articles of impeachment, that were issued by the House of Representatives while he still served as president. Is that constitutional? Can an ex-president be tried in the Senate on articles of impeachment that were issued and voted on by the House of Representatives while he was still serving as president? The answer to that question is clearly no. Under the text of the Constitution, under the policy of the Constitution, and under the intent of the framers. So today, we're going to do a seminar on the constitutional issue of whether a former president or any private citizen can be tried by the Senate for impeachable offenses, even if there were impeachable offenses. This president has never been charged with impeachable offenses. Yeah, the Congress broke the record. They twice impeached the same president. But the record they really broke is they twice impeached the same president, both times on non-impeachable grounds under the Constitution. But put that aside for a moment. Let's assume that they had come up with the most impeachable crimes. Let's assume they had come up with treason, with bribery, with you name it, extortion, all proper under the Constitution. But he had left office either by resignation, as Nixon did, or in the normal course of events. I mean, obviously, the implication of putting him on trial would be that President Nixon could have been put on trial after he resigned. Nobody suggested that as far as I can remember. Maybe it was suggested. It certainly wasn't taken seriously. I don't think anybody thought that President Nixon, former President Nixon, could be tried for impeachment and disqualified from future office holding the moment he resigned. And here we have an even stronger case because there's no resignation. The term simply ends. He's no longer the president of the United States on January 20th at 12:01 p.m. So the seminar on the Constitution, any constitutional seminar must, of course, begin with the text of the Constitution. So let me read you the three relevant provisions. The first provision, obviously, is the one that empowers the Congress to act. The president shall be removed from office, shall be removed. That's the phrase, shall be removed from office on impeachment for and conviction of treason, bribery, or other high crimes and misdemeanors. So it's obvious in the Constitution. Impeachment is designed to remove a president. Okay, there's another provision of the Constitution that says judgment in cases of impeachment shall not extend further than to removal from office and disqualification to hold future office. It doesn't say or is in the disjunctive. It says and in the conjunctive, which means that the only way you can disqualify a president from future service is if he has been removed. Removal from office and disqualification, not removal from office or disqualification. There's no experience in history where a president has been removed or left office, like Nixon, and has been impeached and convicted after he's a private citizen. There is one case where a cabinet member resigned moments before he was impeached, and the Senate had a vote. They actually had two votes. First, they voted preliminarily to see if they had jurisdiction, and that vote passed by a very narrow vote. It was wrong. It's no precedent. It was wrong, but it passed. But then he was tried. And almost everybody thought he did what he was tried for, that he committed impeachable offenses. But 20-some-odd senators voted to acquit, and he was acquitted, not on the ground of innocence, but on the ground that the Senate had no jurisdiction to try him once he had resigned. So that's not a precedent in favor of being able to try a former office holder. It's at best a precedent that's neutral, one vote going one way, one the other way. And at worst, it's probably a precedent against it, because in the end, the Senate voted essentially that it had no jurisdiction. It voted to acquit him, not on the merits, but on the basis of many senators believing there was no jurisdiction. In any event, the idea that a president can continue to be tried after he leaves office is so clearly in violation of the text and policies of the Constitution that even if there were a single precedent against it relating to a former cabinet member, it would not either bind the Senate nor would it bind the courts. Ultimately, this issue could be resolved by the United States Supreme Court. The United States Supreme Court is not going to look to a single precedent, a divided vote by the Senate, which resulted in acquittal. It will look at the text of the Constitution and the policies of the Constitution. And it will find, by looking at the text, and it will find, if it goes back to the framers' intention and the debates over the Constitutional Convention, that impeachment was designed to remove a sitting president. It was not designed to prevent a former president from running. Also, if they were to try an ex-president, the question arises, who presides? It says, when the President of the United States is tried, the Chief Justice shall preside. The Chief Justice shall preside. So does John Roberts preside over the trial of a former president? Doesn't say that in the Constitution. Why doesn't it say that in the Constitution? Because the framers never contemplated that a former president would be tried. And yet there's another provision of the Constitution which is equally powerful and equally persuasive. The Constitution explicitly prohibits two things: no bill of attainder or ex post facto law shall be passed. So what's a bill of attainder? A little bit of history. This is a seminar, so you got to tolerate 60 seconds of history. Before the United States was established, Great Britain used to use bill of attainders. They were legislative actions. The legislature would name a person. Could be a king, could be an ordinary person, could be somebody else, a royal person. They would name him, and they would vote to execute him or vote to imprison him without a judicial trial. It could be a legislative trial, but without a judicial trial. And that was a bill of attainder. And as soon as the framers got together, remember, the Bill of Rights weren't enacted until after the Constitution. But in the body of the Constitution itself, no bill of attainder shall be passed by Congress. And the Supreme Court has defined a bill of attainder as a trial by the legislature which can impose disqualification, any punishment, including disqualification, without a judicial trial. And here, if they put ex-President Trump on trial, he wouldn't have a judicial trial. He would have only a legislative trial. The Senate would serve as the jury. Now, the Senate of the United States has no power to serve as a jury, except in cases of removal of a president. That's the only exception. There's nothing in the Constitution that says that a president, that the Congress, that the Senate can have a trial to determine who can run for office. If that becomes a precedent, think of what it will mean. Let's assume the Democrats now control both the House and the Senate. Let's assume in the next election they become overwhelmingly empowered, that they get 2/3 of the Senate and they get a vast majority in the House, certainly possible. And then let's assume a great Republican candidate comes along. I don't even imagine who it would be, but a great, a real star comes along. And the Democrats are scared out of their wits. They say, my God, this guy's going to beat us in 2024. So in 2022, they decide to impeach him. He's an ordinary guy. He's a CEO of a company. He's a governor of a state. He's, who knows? He's a professor. And they decide to simply impeach him. And so the House comes up with some contrived arguments about what he might have done, and they impeach him. And then there's a trial in the Senate of Mr. Jones. and the Senate convicts him and says he can't run for president. Imagine that. The legislature determining who can run for president and who can't run for president. That's the implication of allowing the Senate to put on trial a private citizen. And so I don't think it's going to happen. But what happens if they agree to do it? And apparently, both the outgoing and incoming majority leader of the Senate think it can be done. Doesn't make them right, but they think it can be done. So let's assume that the president leaves office on the 20th, and the next day a trial begins, or that day in the afternoon a trial begins, and he is asked to present a defense. What defense should he present? Well, there are at least two possibilities. One, he can defend on the merits. He can say, look, my speech was not an impeachable offense. It was protected by the Constitution. I think that would be a mistake. I think his best defense, and if he had asked me advice, and he hasn't asked me advice, I would say that his best defense would be to deny the jurisdiction of the Senate, to say, look, I'm a private citizen. You have no power over me. I will not appear. I will not have lawyers appear. I will not present a defense. I will take you to court and then bring a lawsuit that would ultimately get to the United States Supreme Court. That would answer the question that this seminar, this law school seminar today poses. Can a private citizen be tried in front of the United States Senate for purposes of preventing him from running in the future? The response would be, wait a minute, we're not just plucking people out of the ether and putting them on trial. This is a man who has been impeached while he was in office. And the trial maybe could begin even on the 19th, conceivably, the day before he leaves office. So the issue is not, can somebody be plucked off the street and put on trial? The issue is whether the process of impeachment and removal can continue after a president who's been impeached is no longer president of the United States. And that's a slightly closer question, but I think the answer is as clearly no as it is to the abstract question of whether a private citizen can be tried. Once Mr. Trump is no longer president, the Senate simply has no authority to try him because they can't remove him. You can't remove somebody who is no longer president. They couldn't remove Richard Nixon because he was no longer president. And so if I were the president, and I'm not his lawyer, I'm not his advisor, but if I were advising the president, I would say fight this case in the courts, not in the Senate, because in the Senate, the votes are against you. The Senate is going to be controlled as of January 20th, or as soon as they certify. The two new senators from Georgia will be controlled by the Senate as the result of the tie-breaking vote by the Vice President of the United States, who is a Democrat. So why put yourself at the mercy of political theater? Why not go in front of courts and challenge the jurisdiction of the court? Would he win? I think there are two questions. Number one, would the courts take the case? Is this a political question? Do the courts have jurisdiction to tell the Senate what to do? Well, I think they do, because the Constitution has separation of powers. And if the Senate begins to take powers they don't have under the Constitution, powers that are reserved to the judiciary, then I think the courts have a role to play in vindicating their own authority to try people for crimes or other offenses, or even civilly, or for disqualification. And that would be an interesting issue. The other issue is, if the court took the case, would they agree with my reading of the Constitution? I think they would. I think if they took the case, they would agree with my reading of the Constitution, because my reading is supported by the legislative history. My reading is supported by judicial opinions. My reading is supported by logic and common sense. But we don't know for sure. And so that question remains open. And we may see an answer to it, because the president may, in fact, challenge the jurisdiction of the Senate. He may challenge it in the Senate first, and he may challenge it in the courts. We don't know. I don't know what the president's plans are. I don't know what his lawyers are thinking, but I do think the better approach would be to challenge the jurisdiction of the Senate, because that would establish such a dangerous precedent. The Senate trying ordinary citizens. And then trying them for what? For things that aren't impeachable offenses, for things that aren't crimes. It would create such a distortion of the rule of law that I hope in the end, wiser and more mature minds would prevail. And once the president leaves office, let's just move forward. Let's move to the Biden administration. Let's give the Biden administration its 100 days. Let's not complicate the role of the Senate. There are many nominations that have to be confirmed. Yeah, they're talking about maybe an impeachment trial in the morning and confirmations and coronavirus in the afternoon. That's not the way it happens. If you have an impeachment trial, it is all consuming. It will take up all the energy of the senators. Remember, normally when the Senate convenes, half a dozen members are there. During an impeachment trial, every single member must be there. Hopefully wearing masks and hopefully social distancing, though it's a little hard to social distance in the Senate. But I think it would be so much better if the matter would just drop. He's been impeached. That will remain forever on the books. I don't think it's fair to impeach somebody who can't be put on trial to defend himself, but that's a different matter. But the idea of now going to a Senate trial in order to disqualify him, a trial that's probably unconstitutional, a trial that's probably illegal, and a trial that may well be struck down by the courts, is a foolish waste of American taxpayers' money, of priorities, and I think is not good for the Biden administration. I think Joe Biden, who I've known for 40 years and admire and like personally, I think he'd be so well advised to take on the extremists of his party and to say to them, look, I'm now the president. I want to move forward. I don't want my administration to be taken up by focusing on Donald Trump. We've had enough focus on Donald Trump for 4 years. Let's move the focus away from Donald Trump to Joe Biden. If I were Joe Biden, I'd be pushing for that. So what do you think? You've heard my seminar. Normally in a seminar, we have an exchange of views right there and then. My seminar is a little different. I get to say my thing. You then get to say your thing because you're the wits of the Dershow. Dershowitz, you're the wits. So let's turn to the wits now. Questions and comments from Rumblewitz viewers, from viewers on YouTube. The numbers of subscribers on Rumble are going up dramatically. Also on YouTube. Please subscribe to the show. Please listen and watch the show. And please call in your comments. So we're turning now to your points of view on the Dershow. Our first call this morning is from my old neighborhood in Brooklyn, Bay Ridge, which is very close to Borough Park, where I grew up.
Hi, Mr. Dershowitz. This is John O'Brien. I'm from Bay Ridge, Brooklyn. I'm calling you to see if is it possible that I know that you represented President Trump for the first impeachment. Is it possible that you could do it a second time around and represent him again? Thank you. Bye.
Great question. Everybody's been asking me that question. Every newspaper in the country, every media has been asking me that question. Here's my view. This is not a legal proceeding anymore. This is political theater, and I'm neither a politician nor an actor. I don't see a role for a lawyer in this case. After all, no lawyers were even asked their opinion during the impeachment. Impeachment was just a vote, congressmen blabbering on for their 30 seconds, but no opportunity for the president to present a defense, no briefs, no role for a lawyer. I think the same thing will be true if there is a Senate trial. If the trial begins on the 19th, there'd be a one-day trial. Or if it continues after he's left the presidency, it will be an illegal and unconstitutional trial. So I don't see any role for a lawyer. I will continue on the Dershow and in other formats to defend the Constitution, particularly to defend the First Amendment. I see that as the most valuable role I can perform because so few people are doing it. The Harvard Law faculty seems almost unanimous, not quite, but almost unanimous, against the First Amendment. And I think that's true of many faculties around the country. If the shoe were on the other foot, if this were President Obama or President Clinton, who are being impeached for the same speech, the same professors would be making exactly the opposite argument. They'd be defending the free speech. They'd be defending the Constitution. They'd be defending the Democratic president. That's not the way I analyze problems. For me, it's the Constitution first, and the person, the individuals, much, 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 much less important than the constitutional principles and precedents. So no, I don't think I'll be playing the same role that I played in the first impeachment, because I don't think this impeachment will follow the course of the first impeachment, where there was a real trial in the Senate and the president was acquitted. Thank you for your call.
Hi, Professor Dershowitz. Could Congress impeach and convict the president for an offense that is just clearly protected under the First Amendment? For example, could Congress impeach a president for being an atheist or a Jew or whatever religion, which is just clearly protected by the First Amendment? And if they were to do so and vote in favor of conviction, what sort of relief is available under our system?
What a great question. Wow, that would be the kind of question I put to my students in first-year law school. The answer is clearly not. The Constitution provides that no religious tests shall ever be required for holding office under the United States. So although a number of senators have said in the past they could never vote to confirm an atheist, they would be violating their oath of office if they voted not to confirm an atheist to the Supreme Court or any other place just because he was an atheist. Oliver Wendell Holmes was an atheist. Felix Frankfurter was an atheist. There are probably some atheists serving on the Supreme Court today, but they're closet atheists because it's not popular to express those kinds of views. Certainly, if a person were disqualified because he were a Jew, the way Justice Brandeis, who emerged as one of the greatest justices in history, was disqualified by the Bar Association because he was a Jew, and many leading Bar Association figures, including some whose names appear on law school pictures and law school rooms, opposed Brandeis because he was Jewish. That would be unconstitutional. And I do think, and here I can't be absolutely certain, but if a president were to be impeached because he was an atheist, I think the Supreme Court would unanimously 9-0 take the case and reverse the impeachment. I think that would be one of the few exceptions where the Supreme Court would actually say, no, you cannot violate so many terms of the Constitution, not only the terms about how you impeach a president, what the criteria are, but the express prohibition against requiring a religious test for holding office under the United States. Great question. I think is a pretty clear answer. Let's turn now to our next call.
Hi, Professor Dershowitz. I really enjoy your show. My name is Joe from Oceanside. My number is 516-524-0325. My question to you is, given the fact that the left has demonized and canceled all Trump supporters and people associated with Trump, and they're getting away with it, do you think they're going to use this for cover to demonize and attack the pro-Israel community? I'd like your thoughts on this. Thank you.
It's a great question. The pro-Israel community is divided. Jews are divided. The pro-Israel community is divided on many issues. A majority of Jews voted for President-elect Biden, as they always have, for Democrats. But there are elements of the pro-Israel community, the very strong pro-Israel community among Orthodox Jews and among conservative Jews who have associated themselves with the Trump administration and voted for the Trump administration. Some have served in the Trump administration. And I think there will be efforts to try to use that against Israel. I'm sure AOC and her squad will try to use these issues against Israel and against support for Israel. I don't think it'll work. Joe Biden has had a long history of support for Israel, critical support at times, but even my support for Israel is sometimes critical. I don't approve of all of its policies, nor do I approve of all the policies of my own country, which I love. Being critical of a country does not make you anti that country. So we have to be on the lookout and beware and make sure that this kind of new McCarthyism that is being directed against Trump supporters or people who work for Trump, Harvard has a petition to withdraw the degrees of students who earned degrees years ago, summa cum laude, magna cum laude degrees, but who went to work for the Trump administration. They're trying to withdraw their degrees. It won't work because I think Harvard would lose its federal funding if it did that, and I would sue it. I would defend any Harvard law or any Harvard college graduate who had his or her diploma rescinded, degree rescinded. But that shows you the mood of the time, the McCarthyism of the left that we're living through today. So we'll fight back on the Dershow and in every forum available.
I'm calling about the demonstration or rally that Trump's enemies are calling it a vile demonstration. There were 100,000 people there and a few rioters, and they're condemning the whole rally. I think that's a mistake, and I appreciate your comments, and I'm glad I happened upon this show. But why are journalists, commentators focusing so much on this rally and forget to compare it to the summer demonstrations, aggravation, fires, tearing down statues? Why? Why are they focusing on what happened at the Capitol? It's bad, but there were 100,000 walkers.
That's a great question. And there are really four separate elements. They're overlapping, but they're separate elements to what happened in Washington. There are those who just went to the rally and listened to the speech. They're perfectly constitutionally protected. The speakers had a right to speak. They had a right to listen. Nobody should punish or even condemn people who went to listen to the speech. Okay, that's one group. You say 100,000. I don't know the numbers, but whoever they were. Then there's the second group that marched to the Capitol. That group, as long as they remained outside the Capitol, as long as they showed their flags, even the Confederate flag, which is constitutionally protected, even wearing racist shirts, Auschwitz camp, not enough Jews were killed. All of that's horrible, horrible, constitutionally protected. So you have group one went to the rally. Group two went to the Capitol, constitutionally protected. Then you have two more groups. Group three are those who trespassed into the Capitol. They broke through security, they trespassed, they walked through the Capitol rotunda. They are guilty of trespassing on government property. Not a serious crime, but they're not innocent. And then there are the real villains. The people who broke windows, the people who stole material from the offices of members of Congress, the people who broke onto the floor of the Senate and House, and obviously the people who engaged in violence, the man who threw the fire extinguisher at the police officer, killing him. So we have to separate out all of those elements. And we should do that whether it's a Black Lives Matter demonstration, whether it's a pro-Trump demonstration, whether it's a Million Man March demonstration, whether it's a feminist demonstration. You always have to separate out the legitimate listeners, the legitimate protesters, those who trespass illegally, and those who commit more serious crimes. Let's hope the media learns how to do that and doesn't paint with too broad a brush, because the broad brush you're painting with violates the Constitution. And the Constitution requires a distinction between people listening, people legitimately protesting, and those who commit crimes. That's the essence of our Constitution, distinguishing between constitutionally protected acts and criminal acts that are not protected by the Constitution. Great question. Thanks for asking it.
We would be pleased to send a complimentary DVD of this program to anyone who wishes to support JBS with a tax-deductible gift of $36, double high or more. Simply visit the JBS website at jbstv.org and click on the donate button to make a donation by PayPal or your credit card. And please indicate the program for which you would like a DVD. Or you can send your tax-deductible check to JBS, Post Office Box 360, Stamford, Connecticut 06904. Or you can call the JBS Pledge Line at 833-MY-JBS-TV. That's 833-695-2788. And again, please remember to indicate which program you would like to receive with our compliments. We thank you for your kind support.